My name is Mariana Pardo. I'm the director of the HUBZone program. And today we're going to be talking about a little bit more advanced conversation about HUBZone protests, affiliation, different elements of contracting requirements for the HUBZone program. I'm joined today by Laura, one of our attorney advisors from the Office of Procurement Law. Her name is Laura Foster. These are the items that we'll be talking about today. We are going to be focusing on how we evaluate affiliation to calculate size, also to make sure that the applicant firm is meeting principal office, and that the firm is also meeting the 35% employee HUBZone residency requirement. We're also going to be talking about joint ventures, specifically HUBZone joint ventures, and what are the steps that we need to do to comply with HUBZone contracting requirements. We're going to be also addressing competition for HUBZone contracts, the type of contracts available, and how to file and survive a HUBZone status protest. I'm going to be turning it over now to my colleague, Ms. Foster, to start talking about the affiliation matters. Go ahead, Laura.
Thanks, Mariana. So, affiliated companies for HUBZone program purposes. Actually, Mariana, did you want to talk a little bit more about how this impacts just the overall purpose of the HUBZone program, and then I can take over when we start to get into totality of circumstances?
Definitely, of course. The HUBZone program, the purpose of the program is, as this slide indicates, is to increase employment opportunities to individuals that are living in economically distressed areas of the country. Also, it allows companies to locate and invest in real estate in those areas. So they are performing a lot of different capital improvements, obviously, to that in the past have been neglected. These are areas that are called historically underutilized business zones. So the affiliation, when it comes into play, is to ensure that the funds that the company that is certified, the contracts that they're going to be obtaining, the benefits of the program are going to be channeled to these economically depressed areas as well as the employees that reside in these areas. So one of the aspects of looking at affiliation and how it plays out is to ensure that there is no pass-through. For example, a company organizing itself as a HUBZone firm, obtaining certification, but then basically passing through all the contracts and to an affiliated concern. So go ahead, Laura, and we'll go to the next slide.
So affiliation is defined in Part 121 of our regulations, which are size regulations. So purely for size purposes, businesses are affiliated if one has the power to control the other. It doesn't matter if control is actually exercised. It just the power has to exist, and it can be either affirmative or negative. Negative means that one individual or an entity has the ability to block or prevent an action from another entity. And for size purposes, we look to a number of different factors to determine whether affiliation exists. We look to ownership, management, the newly organized concern rule concerns itself with whether previous relationships exist between the entities, also contractual relationships. We look to whether there's economic dependence between the firms. And then for size purposes, we can also use the totality of the circumstances, which is a test that we use in HUBZone as well. So in HUBZone, when we apply the totality of the circumstances test to determine whether there's a clear line of fracture, we're trying to determine whether the employees of the two firms should be aggregated for purposes of determining compliance with the 35% HUBZone residency and the principal office requirements. I'm sure Mariana talked about those in our previous webinar. Both of those are employee-based. So when we try to determine whether there's a clear line of fracture, we look to a number of different factors. We look to ownership, whether or not they're in the same line of business, whether they share facilities, and a number of different factors that I'll talk about a little bit more in a second. But the totality of the circumstances test is just by its nature a subjective test. So I can't tell you that there's, a formula, common ownership plus shared facilities equals aggregation of employees. It's really not that simple. So we're going to be going through several examples to sort of illustrate the different factors that we consider and how SBA weighs them in making our determinations. So the first example that I'm going to give is Bill owns an IT company, and he's been in business for 15 years, but his company's not located in a HUBZone. So in an effort to tap the benefits of the HUBZone program, he has his wife, Melinda, start a new HUBZone company. And prior to this, she doesn't have any IT experience, but she opens this IT firm in a virtual office that's located in a HUBZone, and she's not a HUBZone resident, so she hires one individual who is. And the firms, Bill and Melinda's firms, have virtually identical websites, and they're obviously both in the IT industry, and they both have similar names. So they also, because Melinda doesn't have any IT experience, the firms have a contract between them that states that Bill will perform IT services for any contracts that Melinda receives and vice versa. So here we would find that there's no clear line of fracture. And the way that we get there is Bill and Melinda share a familial identity of interest. They are husband and wife. Melinda doesn't have any previous work experience, and she appears to be entirely reliant on Bill to perform HUBZone contracts, or really any contracts for that matter. And most importantly, it looks like they started this new company in an effort to engage in deliberate subterfuge, is the phrase that we use. They've started this company solely for purposes of gaining access to the HUBZone program. So because we find that there's no clear line of fracture between these firms, we aggregate the employees. We attribute Bill's employees to Melinda's company when we're determining compliance with the 35% and principal office requirement. So for 35%, we're considering all of Bill and Melinda's employees and whether or not they're HUBZone residents. And for principal office, if Bill has more than one employee, we're probably going to find that the greatest number of employees work at Bill's non-HUBZone location, so we're probably going to find that Melinda's principal office is actually Bill's principal office, or his headquarters. So that would obviously affect Melinda's eligibility for the HUBZone program. And as I mentioned earlier, that would also have some size consequences, but those are not issues that the HUBZone program office determines. Those are determined by the appropriate area office through a formal size determination. So to sort of recap the important factors that we considered there and that we would consider in all cases, we look to whether or not the companies are affiliated, whether they share common ownership or management, if they have an identity of interest, familial or otherwise. We look to whether or not they're in the same line of business and whether they have similar company names. We look to whether they have shared communication information, whether they share email addresses, phone numbers, websites, that sort of thing. I would say that the most important factor that we consider, and this is the first question that I ask our analysts when they come to me with these questions, is whether or not they share resources, whether they share equipment or facilities or employees. Really, it's important that the HUBZone applicant or participant is able to perform contracts by themselves and is not reliant on another entity for these resources. And then finally, we look to whether they share contractual agreements, and those can be in the form of service agreements or subcontracting agreements or leasing agreements, just anything that would lead us to believe that these firms share a close enough business relationship that there's no clear line of fracture between them. So to move on to another example, let's say we have company ABC and XYZ who are owned by the same three individuals. So they have common ownership. Both companies are in the same line of business. They both do construction. One does work for the federal government, and the other only works for state and local government. They have separate offices, they have separate fax numbers, different emails, phone numbers, websites. They have separate employees, and most importantly, each company has a sufficient number of employees to perform their own work for their own company, so they don't subcontract work to each other. So in this case, even though there's shared ownership, which would probably lead to affiliation under size purposes, we would find that there's a clear line of fracture between these companies for HUBZone purposes, and we would not aggregate their employees. So it is important to note that even where there is a clear line of fracture, if some employees are shared, we'll count those employees as employees of the applicant firm. So if ABC and XYZ had shared an accountant, for example, and that accountant performed at least 40 hours of work for, let's say ABC was applying to the HUBZone program, then we would count that employee as an employee of both ABC and XYZ. But we wouldn't necessarily aggregate all of their employees because there is a clear line of fracture there. It's important to note that in these totality of circumstances cases, SBA asks for a lot of documentation and statements from firms. And if SBA feels that you've attempted to deceive us or that you've provided false information or you've hidden information, we will refer those cases to the Office of Inspector General for investigation, and our regulations set forth the potential penalties for fraud in these instances, but they involve both civil and criminal penalties. So it's always a good idea to tell us the truth. So those last two examples that I talked about were pretty clear-cut in terms of whether or not there was a clear line of fracture. Bill and Melinda were obviously acting as one, and ABC and XYZ were clearly distinct entities. But I want to use this last example as sort of a demonstration of how gray it can sort of get. To be honest, when I first saw this example, I wasn't quite sure where we would end up in terms of a recommendation here. Honestly, we would need additional information, but I'm going to go through all of these factors and sort of just lay out what my analysis would be if I were performing a legal review, just so you can get an idea of how SBA weighs these factors and, you know, what sort of information we look at. So here we have All Services LLC, which is a one-person operation who has a contract with Cooperate Inc. to rent office space, and they're going to share a copier, a fax machine, a receptionist, and a conference room. They're both in the same line of business. They have different clients, and they don't have any shared ownership, but All Services LLC's owner used to work for Cooperate Inc. So if I were looking at this, and I see All Services LLC is a one-person operation, that raises a red flag for me because they're in the janitorial business, and if they have, say, more than one contract, I would like to know how they're going to perform that contract with just one employee. Are they going to use Cooperate Inc.'s employees? Are they going to hire more employees? I would want to go back and ask more questions about that. In terms of their agreement to rent office space and share these services, I would also want to know more about the agreement. I would want to know, is it at an arm's length? Is Cooperate Inc. getting fair market value for these things? And so let's say the terms of the agreement, there's a way for Cooperate Inc. to, you know, tally how many copies and how many faxes and how many calls came in for all services, and they're going to bill them for all of those services. I might tend to think that would lead to a clear line of fracture. They don't have a close business relationship, and All Services is probably acting alone if it's getting billed for each of these separate services. But if, say, Cooperate was getting $100 a month for this office space and all of these different services, then I would think that maybe they had a closer business relationship, and we would need to look closer to see whether or not there was a clear line of fracture.
Thank you, Laura. This demonstrates how gray this area is, and the elements that you're looking at, it would help the audience. Let's move now to the HUBZone joint ventures, if we could.
Sure. So let's see. Moving on to contracting, 2 certified HUBZone firms can enter into a joint venture for purposes of submitting an offer on a HUBZone contract. The joint venture itself, so that separate legal entity, doesn't need to be HUBZone certified, so it doesn't have to be on SBA list. But the one thing that you do need to be careful of is the size standards associated with joint ventures for HUBZone purposes. There are special requirements that are set forth in 13 CFR 126.616 definition there. And basically what it is each party to the joint venture has to be small under the NAICS code applicable to the contract. In addition to that, depending on the size of the contract, there are certain dollar thresholds set forth in that section cited there. If the dollar thresholds are exceeded, so the contract is big enough, then the 2 joint ventures in aggregate can exceed the size standard applicable to the government's NAICS code. Then the joint venture parties together have to stay under the size standard applicable to the NAICS code assigned to the contract. So one last thing to note about joint ventures is that the performance of work requirements, which I'm going to talk about a little bit more detail in a second, those do not have to be met by each individual party to the joint venture. The joint venture together can meet the performance of work requirements.
Laura, if I may, I'm going to need AT&T assistance.
Sure.
Callan, I'm having problems maneuvering through the slides at the moment.
You dropped off for just a moment. I'm going to give you presenter rights again. Just double-click my icon blue like you did at the beginning.
Thank you. Excellent. Thank you. Okay, Laura, there you go.
Okay. So if you are submitting an offer on a HUBZone contract, not as a joint venture, but as an individual certified firm, then your firm must be small under the size standard corresponding to the NAICS code assigned to the contract. An important thing to note here is that you have to meet all of the HUBZone eligibility criteria at the time of initial award offer and at the time of award. So this has sort of 2 potential sticking points. One of the HUBZone eligibility criteria is that you're small under your primary NAICS code. So you have to be small under both your primary NAICS code and the NAICS code assigned to the contract. Second is that the attempt to maintain provision that I'm sure Mariana talked about in her last webinar, which basically allows you to fall under the 35% HUBZone residency threshold while you're performing a HUBZone contract, as long as you're making documented efforts to achieve the 35%. That provision will not protect you at the time of offer and award. So you must be in compliance, in full compliance with the 35% HUBZone residency criteria, both at the time of offer and award. And at the time of award, or at the time of offer and potentially your final offer, you're going to have to certify to the contracting officer, 1, that you're on SBA's official list as a certified HUBZone small business concern, 2, that there hasn't been a material change in your circumstances that could affect your HUBZone eligibility, and 3, that you're small under the procurement's NAICS code. There are additional criteria for entity-owned concerns, but those can be found in our regulations. Back to the performance of work requirements that I mentioned earlier. So the performance of work requirements can be found in 2 sections of our regulations. In Part 125.6c, there are baseline requirements for HUBZone prime contractors to meet. So you're allowed to subcontract some of your work, but for different kinds of contracts, the percentages that you are allowed to subcontract are a little bit different. So for services contract, you must spend at least 50% of the cost of contract performance incurred per personnel on any HUBZone SBC's employees. So it can be your employees or another qualified HUBZone SBC's, but it has to add up to 50%. For specialty trade construction, that percentage drops down to 25%. And in supplies, the percentage of work is calculated based on manufacturing cost. So the qualified HUBZone SBC has to spend at least 50% of the manufacturing cost, which excludes the cost of materials, on performing the contract in a HUBZone. Now, unfortunately, our HUBZone regulations add a little bit of complication in this matter. So 126.700 states that for any kind of contract, a firm must spend at least 50% of the cost of the contract incurred for personnel on its own employees or employees of other qualified HUBZone SBCs. And then there are additional requirements for general construction and specialty trade construction. And the way that our regs are worded on this is a little confusing, but basically for general construction, you have to spend 15% on your own employees and a total of 50% on any HUBZone SBC employees. And then for specialty trade construction, you have to spend 25% on your own employees and 50% total. And I realize that that's a little confusing, so if you have questions on that, feel free to email Mariana or myself. And so HUBZone contracts are defined as either a sole source HUBZone award, a contract set aside for HUBZones, or a contract awarded to a HUBZone small business through full and open competition with the use of a price evaluation preference. So the last thing that I'm going to talk about today is how we apply the price evaluation preference. Our regulations state that when a contracting officer is using full and open competition and a price evaluation preference, they must deem the offer by the HUBZone firm to be lower than the price offered by a large business as long as the HUBZone's offer isn't more than 10% higher. So in practice, we're going to use some examples. So if a HUBZone SBC submits an offer of $98, a non-HUBZone small business concern submits an offer of $95, and a large business submits an offer of $93. The way we would apply the price evaluation preference is to add 10% to the large business's offer and then evaluate whether or not the HUBZone SBC's offer is lower than that of the large business concerns. So here, after the PEP is applied, the evaluated prices are $98 and $102. So here, the HUBZone concern would be awarded the contract. However, if the HUBZone concern's price had been more than 10% higher than the large businesses, then the final evaluated price would mean that the HUBZone concerns would be higher than the larges. So at the end of the day, the large would still be awarded this contract if the HUBZone's offer was more than 10% higher. Another thing to note is that if the final evaluated prices of both the HUBZone and the large were the same in this example, then the HUBZone would still be deemed to be lower and would be awarded this contract. The second example, where the non-HUBZone small business concern submits the lowest offer of $93 and the large submits an offer of $95, HUBZone submits an offer of $98. In this case, we don't even need to apply the price evaluation preference to know that the lowest responsible offeror is going to be the non-HUBZone small business concern, because the HUBZone small business concerns offer cannot be deemed lower than a small business concerns offer if that small business is otherwise successful. So I hope that made sense, and I'm going to turn it back over to you, Mariana.
Thank you. Thank you so much. We are going to be going now through competing for HUBZone contracts, some of the steps that companies take, and also talking about protests. Remember that we're not going to be opening this session for questions, but please send your questions and they will be answered. We will send the responses to the participants at a later date. So keep on logging in your questions throughout the presentation and we will be taking those in and responding. The next slide has a few pointers there of how to compete for HUBZone contracts. Same things that you've done on your commercial ventures, you need to perform, obviously, a market analysis to zero in on those agencies that are going to be your customers, that perhaps could be your best customers. Obviously, you're going to be taking a look at what are they purchasing. Am I selling what this are purchasing. Develop a rapport with the small business office in each agency. They're called differently in each agency, but all the agencies have websites. Many of them have very good search engines. So you could put in the search engine small business office or small business utilization office, and then it will prompt you, it will bring you a result of where the offices are located and which individuals there you could talk to. They're advocates for small businesses, and they're a good group for you to establish a relationship with them. They understand what the agency will be buying. They can share with you the forecast, but most important is that they can understand better what you are selling, what you represent, so that then as they continue working with other offices in the agency, they can keep your firm fresh in their mind. Procurement center representatives, these are SBA employees actually that are strategically located in the largest buying activities. So the list is available in that URL that we are including there, and you can certainly communicate with them via email or phone and set up a time if you're physically located nearby, obviously. Important also is to keep your firm's profile, the dynamic small business search profile as well as the SUM profiles up to date. Perform from time to time quick market searches in the dynamic small business search. That gives you an opportunity to compare your services, the way that you're marketing to the federal government, with those of your competition, and also identify perhaps potentials for joint venture, as Laura was explaining to us, the particular requirements for joint ventures. They have some protests. Obviously, when you are very successful in obtaining HUBZone contracts, you will experience a HUBZone protest. It's a very good mechanism for you to ensure that the program benefits is flowing to the intended participants. So most important is to understand how to file a HUBZone protest. The HUBZone protest regulations are delineated in subpart H of the 13 Code of Federal Regulations, Part 126. In there, it tells you a little bit more detail, but I wanted to share with you a couple of things that you can keep in mind to avoid dismissals. First of all is make sure that you understand the time frames, because our office sometimes gets protests that are filed late. So you only have 5 business days after you're notified by the contracting officer of the apparent successful offeror. So keep that in mind. Also, make sure that you're specific. A simple statement that the firm has not been recertified because the HUBZone list shows the firm to have been certified in 2002 and there is no additional dates is not sufficient, particularly because there is information in our website explaining that the display in the dynamic small business search in that list, it does not list the date of recertification. It actually lists the initial certification date. So you have to educate yourselves, reading the HUBZone regulations, understanding the criteria, go to the website, the frequently asked questions, and then you will be better prepared to file HUBZone protest that will be considered. Surviving a HUBZone protest, that's the other side. If you are subject to a protest, is perfectly normal to receive a protest. The system is working as intended. Again, you make sure that you're always are educating yourself about the HUBZone regulations, understand what your obligations are. So what we find is that the firms that are best prepared to survive a HUBZone protest usually have assigned someone in the firm way before this protest was filed for monitoring and documenting compliance. They usually create a HUBZone protest file that contains, at a minimum, evidence of the HUBZone compliance at the time of offer and at the time of award. As Laura was explaining to us earlier, the companies must be in compliance at the time of offer and at the time of award. So obviously, if we are maintaining a HUBZone protest, we need to make sure that we have documents that prove that I was in compliance at the time I submitted my bid and that I'm in compliance at the time of award in the event that I receive a protest. This and the next slide is very busy, but it's important for you to read at your leisure. But these are some of the evidence that should be contained in that protest file that you want to keep in the event that you are protested when the contracting officer notifies that you're the apparent successful offeror. Most important is to note in this particular area right here, you see that you are going to need to keep hard copies or save a file, maybe cut and paste the finding from the HUBZone map and save it into Word perhaps and save it electronically. What is important is before you submit the offer, obviously take a look at your employee pool. Find out, look at the payroll, see all those that are working at least 40 hours in a month are going to be considered employees. And then once you determine the universe of how many employees you have, then do the mathematical calculation, multiply times 35%, and you know that you have a specific amount, a minimum amount of employees in order to meet that 35%. And then you basically look at and ensure that you have that amount. So you will need to ask the employees for photo IDs, those employees that are HUBZone residents, and you will need to make copies of the driver's license or voter's registration cards showing where the employees, their home address being in a HUBZone. You will need to make a copy of the map because you're going to have to check that address against a HUBZone map and make sure that it is in a HUBZone. And the importance for assembling these documents when you're submitting the offer and when you're awarded the contract is because that employee that you were counting as a HUBZone employee may not be in your firm at the time that you get protested. If you submit an offer in January 2013 and then the notification of award comes up in August, there's two things that may complicate matters for you to have evidence in the event of a protest that is logged in terms of challenging that you're not meeting the 35%. One is the employees may not be, the particular employees that you were considering as HUBZones, they may no longer be in the firm. Second is that the maps get updated periodically, at least 4 times a year. We don't maintain historical maps, so it is very important for you to do that snapshot and capture that information at the time of offer. Best practices are several. Basically, the most important thing that is highlighted in bold there is that the firms that are very successful, that perhaps have been certified for 10 years or more, have incorporated the HUBZone certification maintenance into their business plan, meaning that they have assigned somebody that understands and is studying the regulatory requirements, that understands the type of evidence that the firms must maintain to prove compliance, and that most important monitors that compliance and keeps documents regarding the compliance. Particularly the compliance that are most difficult for firms to maintain are the 35% and the principal office. The firms also subscribe to the HUBZone News, which is it provides, all we take is your email address, and we don't flood you with a lot of information, but we do use this periodically to provide the latest information about the program. It may be that we send notices when the map is changing. It may be that we send notices when there is a particular policy change or a particular evaluation that we're performing perhaps a little bit different. This slide here, we are giving you the URLs of the resources and tools for you to utilize. They have some maps. When you click on this URL, it actually does not take you to the map. It takes you to the HUBZone map landing page, which is extremely important. If you want to bookmark a particular web page from the HUBZone website, do not bookmark the HUBZone maps themselves, the geographical representation, because it is in the HUBZone landing page where this URL will take you that we make a lot of announcements and changes. So you want to actually, if you want to bookmark a page, bookmark the landing page, and that landing page does take you to the HUBZone Maps. We also have a calculator tool, and we're giving you the URL there. It is an Excel spreadsheet. It takes a little while to open, but it does take you to an Excel spreadsheet. It is a calculator that we use internally here to calculate 35% and the principal office. You're welcome to use it. We want to make sure that you know what we're using in our office. And again, you're welcome to use it if that will help you. We also, the SBA website has a learning center that is extremely useful. It has a lot of different videos and webinars that have been recorded, and PowerPoint presentations that you can actually understand not only about the HUBZone program, but also about the size. For example, right next to it, there is the SBA size standard tool. This is an extremely useful training tool that you can take. It takes just a few minutes, but you can understand a little bit better the size implications for this certification, but also as a small business, you need to understand how size operates. The application guide is very useful for those of you that are not HUBZone certified yet and would like to know a little bit more what it's going to take for the firm to apply. This is a URL that would take a PDF file. Local assistance is extremely important. Our office here in headquarters in Washington, D.C. is very small. There's only 18 of us now. And all we do here in this office is really monitor compliance, initial compliance for approval or declines, and also continued eligibility compliance. So it is really through our partners throughout the country that you're going to get more hand-holding. You have district offices, you have the small business development centers, the procurement technical assistance centers. In this URL will take you to the local assistance, and you can plug in your zip code and will take you to the closest entities that can assist you. The first here, it takes you to the website. Regulations, again, they're dry, perhaps a little bit confusing from time to time, but nonetheless, it is important for you to know where to find them and to refer to them often. There's a lot of definitions there that are very important. The supporting documentation is also in our frequently asked questions, and it's very important for you to understand the supporting documentation that we asked for so that you're able to maintain it. This supporting documentation is documents that prove eligibility on the different areas for ownership and control, for size, for principal office for 35%, etc. And it is important for you to understand where to find it and consult it periodically, even after you become certified, so that you know what you need to maintain. It's the same type of supporting documentation that we will ask of you when we're performing a protest, an evaluation due to a protest, or when we're performing a recertification evaluation or a program exam, which is a type of audit. The frequently asked questions, this URL takes you to that site, and it has a lot of different examples that further assist you to understand the different nuances of the program in terms of principal office. What happens if I have employees that really do not have their own home, they're sharing a home? What happens if I have a company that it really relies a lot on temporary work, that things ramp up in the summer, spring and summer and fall, and then they die down, and I lay off a lot of my employees in the winter. Those questions and answers will be available there in the frequently asked questions. For more information, you can send us an email. Well, obviously, you can go to our website. You can contact us in the help desk, HUBZone@SBA.gov. Also, we have office hours via a toll-free number, and these are driven by the participants. It's just 1 hour, but we answer questions, and we use the fact pattern that the participants present to us as a stepping stone to talk about a particular element of eligibility. Since we still have 4 minutes, perhaps we can, even though we were not going to be taking questions, perhaps we can find out maybe a couple of questions. I see that there is a question that is, can I have ownership or partnership in companies in two different HUBZone states? This, I believe, let me, since I will need more information, but an owner, and I'm going to ask my partner Laura to chime in, but obviously this relates to affiliation. And an owner or a partial owner of a HUBZone firm can own other companies. They just need to, the company, the HUBZone certified firm, needs to be cognizant of particular elements that may affect its eligibility, as we were talking earlier today. And Laura, perhaps you can give a little bit, kind of like a very quick overview, and that is actually, perhaps this is the only question that we'll take, but this is very important because it goes back to the affiliation size and clear line of fracture and all that, and maybe you can have a couple of minutes to encapsulate that, and then we'll end it on that note.
Sure. So common ownership between companies would likely lead to a finding of affiliation under our size regulations. And there's nothing in our HUBZone regulations actually explicitly allow for affiliated companies to participate in the HUBZone program. The only thing that you're going to have to be careful of is everything that I talked about in terms of the application of the totality of the circumstances test. If there was no clear line of fracture between these two companies, then we might aggregate the employees for purposes of determining 35% and principal office, and that could adversely affect the eligibility of both entities.
Correct, yes. We have there is a question here, part of a question. Protest must be posted within 5 days of intent to award, not 5 days of award date. That's correct. It's 5 business days from the time you are notified of the successful offeror. Correct, Laura? Mm-hmm. Is that? Yes. Yep. So it's basically when you, as an offeror, receive the letter saying ABC Inc. is a successful, the apparent successful offeror, and we intend to award the contract to the company. Then from the date of that notification, you have 5 business days to file the protest. And
if for some reason you don't get that notification, you simply get the notification of award, then it would be from 5 days from the award date. Excellent point.
Excellent point. Yes. One item that I wanted to clarify is SBA, even if we dismissed a protest because it was not timely, if there was enough specificity in that protest, SBA can log in its own protest, and we have done so in the past. So I wanted to clarify that, and you will see that in the regulations. At any rate, we've come to the end, and I want to be respectful of everyone's time. And again, send your questions, and we will be answering them. You will receive the response of this probably very early next week. Thank you so much.